Okay, looks like people are joining. Good afternoon, everyone. My name is Samir Varma. I'm a partner in Thompson Hine's International Trade Practice. I'd like to welcome you all to today's webinar. I'm delighted to introduce you all to our panelists for today's webinar. First is Joan Meyer, a partner in Thompson Hine's White Collar Criminal Practice, Internal Investigations, and Government Enforcement. Thanks, Joan, for joining us today. Becky Rohr, or Rebecca, or Becky Rohr, is Vice President, AntiCorruption Global Trade, Ethics and Compliance Office at Hewlett Packard Enterprise. Good afternoon, Becky. Good to see you. And finally, Mara Senn, who's Director and Senior Counsel of Global Compliance Investigations at Zimmer Biomet. Before we begin, I just wanted to go over a couple housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. We will be offering CLE credit for today's webinar. Please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel located at the right-hand side of your screen. This form provides instructions as to where to send the completed form. I will be announcing the tracking code at the end of the program. Also in the handouts panel, you can download a copy of today's PowerPoint slides, as well as in the additional materials, some posts from Thompson Hine's White Collar Crime blog, Does Crime Pay, as well as bios of today's speakers. I did notice that people are having some problems downloading the handouts. We will be sending out those handouts and the other materials to everyone who participated in today's webinar over email after the webinar is done. I was going to have a couple other ground rules for this debate. This discussion. 2 minutes a person. Let's try to keep it sane here. But I don't think I really need to. I think we're going to be good about this. So let's go ahead and get started. The focus of today's presentation is global trends in anti-corruption enforcement and their impact on U.S. and non-U.S. companies. In particular, we'll be taking a look at recent enforcement trends, international considerations, the impact of COVID-19 on enforcement, some recent guidance documents, also potential legislation here in the US, and we'll end with the discussion on what's next. Again, if you have any questions during the webinar at all, please use the panel located, the question box located on the right-hand side of your screen. We will take a look at those questions and try to answer as many as we can at the end of the webinar. Any questions that we don't get to, we'll email you after and start the discussion that way. Thanks again, and let's get started. So, update on recent enforcement. Obviously, in the FCPA enforcement arena, there's very few cases that actually make its way to the court system. Most often, it seems like cases are being settled, and even those settlement documents offer little insight into sort of how these cases are enforced. Joan, I guess we'll start with you. I know that there was one case that was actually adjudicated in court earlier this year involving a former executive Alstom, Lawrence Haskins. So what happened in that case?
So that's really important, Samir, to note that most of these cases are corporate. They've got some pretty aggressive individual prosecutions, but generally changes in the way that the FCPA is viewed statutorily are going to be based on individual prosecutions and decisions made from district courts. So a large French company, Alstom, was caught up in a number of FCPA violations, and as one of the resulting individual prosecutions, an individual named Haskins was prosecuted by the DOJ in the District of Connecticut. The defense in Haskins had raised an issue regarding whether or not Haskins, who was a foreign national, was a covered person under the FCPA. Now, Haskins was a UK citizen who was working for a UK subsidiary for a French company, and he was alleged to have been working with the US subsidiary of Alstom in engaging two consultants and negotiating their contracts these consultants were instrumental in paying bribes for a government contract in Indonesia. He was charged as a foreign national because he was alleged to be a co-conspirator and an aider and abetter with U.S. subsidiary employees. This was challenged by the defense. It went up to the Second Circuit, and the Second Circuit held that Hoskins could not be held to be a co-conspirator or an aider and abettor if he was not otherwise a covered person under the substantive FCPA violation. So they said he's a foreign national, he was not present in the United States, he was working for a foreign subsidiary. So the only way that prosecutors could establish his liability on the FCPA count is if they could prove he was an agent of a domestic concern, which would be the U.S. subsidiary. What happened is the prosecutors went forward on that theory and argued that he was an agent of the U.S. subsidiary because he did actively participate in hiring those consultants and negotiating those contracts. And in effect, although he wasn't an employee of the subsidiary, he was acting as their agent. The district court and the jury, after being instructed as to general agency principles, came back and found that Hoskins was not only convicted him on the FCPA counts and also on money laundering counts. So that was a victory for the government after a very unfortunate case out of the Second Circuit for them. But the defense moved for a judgment of acquittal on those counts, and to the surprise of the prosecutors, the district court did find in a highly factual analysis that that Hoskins should be acquitted on the FCPA counts because the government did not prove agency. And what the district court said was that there wasn't an ability of the U.S. subsidiary to terminate Hoskins, that they did not control his actions sufficient to prove agency. So disappointment, although Hoskins was convicted on the money laundering counts and sentenced 15 months in prison. The DOJ currently, there has been kind of competing appeals here. The DOJ did challenge that finding by the court and filed a brief at the Second Circuit. I think it was filed in July. What should also be noticed is that Hoskins was a decision coming out of the Second Circuit. There was a district court opinion in an extradition case called United States versus Firtash, which specifically took issue with the Second Circuit opinion in Hoskins. And you can see with some recent guidance coming out from DOJ that they're not willing to give up on their theory of co-conspirator and aiding and abetting liability against foreign nationals. And they specifically cite to the district court opinion in Firtash in their guidance, and also state that the Second Circuit opinion is limited to the Second Circuit. So they haven't given up on their expansive view of conspirator and aiding and abetting liability when it comes to charging FCPA violations.
So what does that mean for, in terms of the Hoskins case, what does it mean for the definition of agent and how we should be viewed, how the government views agency in the context of the FCPA, even though they lost on those counts? It sounds like they lost because of, you know, the facts in that given case, but the view of what an agent is still stays the same. Is that true?
Well, that is true. I don't think that the government, in my experience, is going to be giving up on this very broad concept of agency. What I've seen in my experience is that the government does not rely primarily on corporate formalities. So they're not really looking at whether or not employee A works for subsidiary A and determining whether or not there's an agency relationship there. And in fact, what I've seen in government prosecutions is that they can conflate the corporate structure, and they can make arguments that that an individual is an agent of an issuer. If they're working for a subsidiary, the issuer, or they're working for, either they're involved in an agency relationship related to working for an intermediary. They could basically task or charge the parent or find liability on behalf of the parent. If you've got an individual or a group of individuals working at what I may perceive to be a rogue subsidiary. So they really take a broad view of liability. And I think that anyone that is working in a government disclosure context or defending against a possible government prosecution has to really look at things on a case-by-case basis. And just as you see in this Alstom-Hoskins case, be evaluating whether or not an individual actually is being directed, controlled.
Oh, did we lose Joan?
It kind of looks that way.
Yep.
She was making a very good point there. But Mara, Becky, has this impacted your companies and the way you guys look at agency and your subsidiaries throughout the world?
I mean, in my experience, corporations tend to be very conservative because they, under no circumstance, do they want to be Alstom being talked about at a presentation. And so I don't think the reason that so many corporate settlements occur is that what's at stake is their reputation. And if you're a corporation and your name is constantly in the news, the way Alstom has been, then that's just net bad, no matter what. So once you're in the, in the sights of the government, if you're a big company who cares about your reputation, chances are you're going to push back and fight as much as you can and narrow it as much as you can. And if you must get a resolution, you're going to do that rather than going to court. And so, and I think most sophisticated companies now have very sophisticated compliance structures in place, and they're all geared towards the same thing, which is to make sure that this kind of thing doesn't happen. Now, the incentives are completely different if you're an individual, because you might have to go to jail. So you don't really care if your corporate employer says that's bad for our reputation, because your rejoinder is, okay, but I'm going to be in jail, so I'm fighting this myself. And that's why most of the cases that we see on FCPA are not corporate cases, they're individual cases. And because of the broad theories that the government has that are not typically tested in court, the individual cases is where they're tested in court. But again, like Joan said, even if they lose, they can still press these theories in their corporate resolution. So that's why they don't want to give it up. It's not, in part, it's just on principle, but it's also when they negotiate with a company, if the company is like, well, this guy wasn't even our agent, so we're not liable, that does not help them, the government, with corporate liability. So of course, they're going to leave all their options open.
I agree with Joan's main takeaway, which is that DOJ takes an expansive view of agency, and although the Hoskins case was a setback, DOJ is inclined to look at this as limited to the facts and potentially limited to the Second Circuit.
Yeah, I agree. Well, let's talk a little bit about just enforcement generally over the past year or so. Obviously, the President Trump has been pretty outspoken about his sort of, I don't know what the right word is, disdain for the FCPA and anti-corruption laws generally. He has said in the past that it's sort of unfair to U.S. companies. It doesn't put them on equal footing as some of their foreign counterparts. I know we talked a little bit about sort of the pressure to reduce enforcement, but how do you think that's all played out over the years, or the last few years, or even this past year? Has there been any impact on enforcement or sort of enforcement priorities at all?
I think that although President Trump clearly was not a fan of the FCPA and made those comments, I think in around 2012, there's a couple of significant developments since then, in that lots of other countries now have stronger anti-corruption laws and are enforcing those laws. And so his concern that the U.S. shouldn't be the police of the world is no longer as relevant, because there are lots of other enforcement authorities who are pursuing corruption cases. And we have not, in my view, seen it play out, in that there are still lots of FCPA investigations and enforcement activities. And so I think that we have not really seen a change over recent years in terms of FCPA cases being brought by the DOJ and the SEC.
Yeah, and I would just say,
I'm back again.
Oh, yay. Hi, Joan. We can't see you though.
Sorry.
That's okay.
Unfortunately, I'm sorry about that. Obviously my view on enforcement is really colored by the fact that we've got COVID, and while I've seen engagement by the DOJ and the SEC, I think it's just become very challenging in this environment right now to conduct international investigations and get things resolved.
Yeah, and I mean, the way it works at DOJ, I'm sure a lot of people on the phone know this, but there's a layer of civil servants that are, the bulk of everybody, the bulk of the people who do the work on FCPA cases are civil servants. So you have to go up 2 or 3 layers before you get to the political. So even if the Assistant Attorney General for the Criminal Division agrees with Trump and wants to quash, for some reason, the FCPA unit, they still have a ton of lawyers that are working on it. And really their effect is really going to be at the margins. They're not going to pull, well, they haven't yet pulled funding for that unit. And really, they're not also going to reach down for the smaller cases. I think where it makes the most difference is, politicals typically don't review the everyday cases. It's getting a little more common under Barr, but still not very common. They only have so much time. And so, what happens is when the big cases are at issue, the frontline headliner cases, it can make a difference there, because they can say, well, you haven't made your case, or we don't think this should go forward. But those are, and that could happen on the larger cases, or give them more generous settlement, less of a fee or whatever. But in terms of, just the pure volume, most of the cases under FCPA are not front page news. I mean, unless you're an FCPA geek like we are all on this panel and probably half the audience. So really, I think it's difficult for political pressure to be put. Again, there are some notable exceptions that have happened in the Justice Department, obviously in the last few months. But really, in terms of just trending over time, I don't think the political pressure is really going to have much teeth, and hasn't up to date.
Yeah, I tend to agree. I think that there in the news there are sort of a couple large cases per year that everybody hears about, and the ones that are in sort of the $1 billion range. And this year was no different. There was a very large case involving Airbus that was, I think a $2 billion settlement. But in terms of number of cases, it sort of has been steady over the years. Some years increase, some years decrease slightly, but it seems pretty much that the enforcement priorities have stayed the same.
There may be, I think just from a political perspective, there may be issues in investigation and cooperation by other countries. There certainly is a tension between U.S. and China now, and conducting investigations involving China. I think to the extent that the U.S. government is seeking some form of assistance, in those types of circumstances, depending on what an administration's priorities are, you could see hurdles in completing an investigation and getting it to resolution quickly because of the political obstacles But as Mara said, I think that the DOJ and the SEC are largely relying on, in the FCPA context, disclosures by companies and thorough internal investigations conducted by companies, possibly in multiple countries, to get them the information they need to fashion a resolution.
Yeah, it's a good point, and actually a good segue to our next topic, which is the international considerations, and in particular coordination between these U.S. and foreign governments. Joan just mentioned China. It's obviously important for regulators to be talking with each other and coordinating whenever there's a enforcement action. But what are some of these considerations here? Maybe Becky, if you want to take this one.
Yes, thank you, Samir. Over recent years, we have definitely seen increasing coordination among U.S. authorities and their foreign counterparts, are there either enforcement authorities or regulators. This is a definite trend, and I expect to see it continue. And there's a few different ways that this coordination can work. One is the foreign authority provides assistance to U.S. investigation, such as provides evidence in response to a formal request. Or second, there are jurisdictions, and this is happening more and more, that are conducting their own investigations into the potential corruption in parallel with U.S. authorities and coordinating amongst each other. The coordination in doing these parallel investigations can play out in a couple of different ways. It can make it easier for the U.S. to get evidence and different types of evidence than normal. For example, in some countries, it's easier to wiretap citizens. And so if the U.S. is conducting a parallel investigation with one of those countries, they can get evidence that they might not otherwise be able to obtain. And it can be easier to get evidence faster. If there's informal relationships and parallel investigations, then the U.S. government can have access to materials faster than waiting through the formal process. On the other hand, sometimes we've seen that coordination among international authorities can really slow down an investigation. So it can work either way for companies that are under one of these investigations involving multiple authorities. And as we talked about earlier, even though the current administration seems to prefer in some areas of foreign policy to go it alone, we have not seen this in terms of parallel FCPA investigations. There still is a lot of coordination. And how do we know that? Well, one way is we can see it in DOJ press releases. If you look at the press release in an FCPA case, there's a section at the end where DOJ thanks the countries that have provided assistance. And you can see it in thanking countries for their cooperation in providing evidence or in actually conducting their own investigation in parallel. And you can also see it in the recoveries that one company is paying to multiple authorities at the same time. And you can see it from what's known as the piling on policy that was released in May 2018. It's formally called the Policy on Coordination of Corporate Resolution Penalties by then Deputy Attorney General Rod Rosenstein. It instructs prosecutors to consider the penalties and the fines that are assessed by other enforcement authorities. So this is an implicit recognition that defendants are having to pay multiple authorities for the same misconduct, essentially. And we can see expanded coverage. We can see expanded coverage of international issues also in the new FCPA guide, which we'll be talking about later in the presentation. And so I'll make one final point on this section. Companies that want to resolve different investigations at the same time need to ask for it. Criminal prosecutors typically won't suggest it because it can seem heavy-handed for them to do so. And so a company that's under investigation by multiple authorities and want it to be coordinated so that they can make one announcement at the end and have one final resolution with one set of payments, they need to say that they're interested in pursuing a global resolution.
I think that's really important. It's a challenging issue for companies to pragmatically kind of approach, it really depends on whether or not you're in a series of countries that has aggressive enforcement. So for instance, Brazil and the United States, very often these days, you've got the Brazil government that is aggressively investigating the case and is actually taking the lead, and the U.S. is playing second chair. Whereas if you have an investigation in another country that is not as coordinated, the question for a company would be whether or not that particular country is actually going to take an enforcement action. And sometimes I found it's compounded by the fact that some countries have local anti-corruption laws without a statute of limitations, so they don't feel the same pressure that, let's say, the United States would feel in moving forward on an FCPA case, and can follow up maybe 3, 4, 5 years down the road, which makes it, again, challenging for a company because you can't expect the DOJ to wait for, the other country to get up to speed and move faster, expedite an investigation, and in fact, may not really even be investigating until the DOJ concludes its case, and then they want to do their own investigation locally. So very difficult issues when you're dealing with multiple countries.
Yeah, and you can see that in that there's, obviously, into the next bullet point, there's new anti-corruption laws popping up. We talked about this briefly a second ago, but there's a lot of new anti-corruption laws popping up, or even sort of being more enforced or in use over the past few years. What are some of those that have been new and enforced?
Yeah, so one of the interesting things is the breadth of different countries that are passing anti-corruption laws, because some of the countries barely have civil societies. They are incredibly corrupt, but they're still passing these corruption laws, some of which will be enforced, some of which will absolutely never be enforced. And the question is why? Like, why would you bother to pass a law that everyone knows you're never going to enforce, or that you don't have the capability or the capacity to enforce? And that's obviously not true for all countries, but it is true for a lot of countries. So there are a couple pressures that come to bear on countries around the world. One big one is that if your economy is in free fall, like I'm sure many are and will be because of this crisis, you need funding from international sources, the IMF, the World Bank, other places. All of those funding sources now have requirements that countries have an anti-corruption framework at least in place. And so when the IMF goes in, or the World Bank goes in, or another funding agency goes in, one of the things they're going to look at is benchmarks of, okay, how are your internal controls for your country? And obviously anti-corruption is one of the numerous factors they look at, but anti-corruption is definitely in there. And so the Financial Action Task Force, which is called FATF, and OECD, both of them do evaluative reports periodically on different countries. So if you're the IMF and this country has just had a bad FATF report that says you haven't followed the following 6 things that we recommended, the IMF and other funding agencies are going to pressure that country and say, we're not giving you money until you've done the following 3 things. So that's one sort of pressure that's on the countries. The other thing that's an interesting pressure point is sometimes the countries themselves are experiencing, they're experiencing pressure internally. So either political pressure, there have been massive protests in certain countries that have resulted in laws that have been passed. So those are kind of the two, the international pressure and the national pressure are 2 different places, and sometimes they're working together, sometimes they're at odds, but that's sort of the context in which these laws have passed. So I'm just very briefly going to go over a couple laws that have been passed, and I'll give a little thought as to why. So in Turkmenistan, which is like a horrible dictatorship that has 0 enforceable laws, they actually passed a law in December 2019 to exclude prisoners convicted of corruption from state amnesties and pardons, because every year they go through like a pardon system. And now if you're corruption, you can't, if you've been convicted of corruption, you can't be pardoned. Well, why did that happen? It happened because the dictator had to fire his interior minister for graft. Whether that was really a political reason, it was just, that was, you know, cover for that, who knows? But then he can say, I care so much about corruption that I fired my guy and I passed a law. Okay, so that's one thing. I think we all know that is not going to be enforced. In South Korea, they increased their corruption. They've had a couple corruption scandals, and they have increased their penalties and allowed use of wiretapping for corruption cases. Why did they do that? Because the OECD gave them a report that says you should really do that. So they did it. Armenia, they passed a new unexplained wealth. I actually did a training in Armenia on all the people who are involved in this case. It's really, really interesting. So in 2018, Armenia they voted in a new kind of reformist government. And so everybody in the whole corruption community and the asset forfeiture community and the kleptocracy community is very excited about Armenia. But like with most countries, you only have so much time and you have to prove that you're actually reformist in order to, you know, once you're elected, you have to actually, you know, deliver. And so they actually passed an unexplained wealth law similar to the UK law, where basically if somebody has a lot of money and people are like, why do you have all that money? The government can basically freeze it and say, we're not giving it back to you until you prove to us that it's legitimate. At the same time, the government also can prove that it's connected to bribery. The other thing, and this was very controversial when I was in Armenia, is they have a banking law that basically allows you, as it stood at the time, and I believe it's been passed now, you could only get banking information if you already had criminal charges that were legitimate in a certain like small category of crimes. Now, the bank secrecy law will allow law enforcement to get access to banking information, which is everybody who's done financial investigations knows is completely crucial because it's the money trail. But the political context for that particular one is Armenia was a Soviet state, and the state used to use that information constantly against people. So they would seize their money if they knew where it was. And so there's a very strong culture of secrecy for personal protection and autonomy from the government. So it was a very, very controversial law because of the unique historical situation of that country. So there, you know, that's also a sort of an interesting issue. And then Lebanon also passed a new corruption law. And the reason they did it is they had mass protests against the corruption. Their economy is in free fall, and because they're negotiating with the IMF, who said you better pass some laws, which they did. And then finally, Malaysia passed a law in 2018 that just went into effect in June of this year. You know, and all of these are very similar laws. I mean, besides Turkmenistan, which is kind of an outlier, but most of them are like very similar to kind of the corruption laws you see all over. And so is Malaysia. But the reason that they passed that law is because of a case from my old unit called 1MDB, which basically found that the prime minister, his wife, you know, his stepson were all basically raiding the sovereign wealth fund, and it was a humongous scandal. And he was voted out of office. And I can't remember, I think he was voted out of office, and then this was passed, this law was passed. But basically that was both international, because it was an international case and everybody knew about it. And in that case, for example, we worked very, very closely with the Singaporean government and a number of other governments to get that done. And then of course, once the government changed over with Malaysia, so that was another, and then there was internal pressure because they had voted him out, and everybody was very angry when they found out all the plundering that had gone on, you know, based on state money. So that's just a few highlights of the anti-corruption laws around the world.
I think that it's very interesting to see what's going on with anti-corruption laws. I know that Mara and Becky are aware of all the movement, I think, that you see in Europe and in South America, either discussions or new laws passed that are attempt to hold corporations criminally liable. In the past, that they were held administratively liable and subjected to penalties, but you're seeing a lot more movement towards corporate criminal liability, with protection of whistleblowers, attempting to give financial incentives to whistleblowers, and mitigating factors that are now encompassing the effectiveness of an compliance program. So the compliance program, if it's effective, can operate either as an affirmative defense or a mitigating factor in terms of a penalty. And another thing I've seen too is increasing emphasis on corruption regarding procurement fraud in particular.
Yeah, and one trend I definitely saw, because this was the area I mainly focused on when I was at DOJ, is, the unit I was in, we seized money from foreign dictators, and then this is the key, we would then give the money back to the country that had the money stolen from them. So now a very sort of hot area that a lot of countries are trying to pass, and because like things like Armenia, it can be tricky, is a lot of countries want to have kleptocracy laws so that they can seize the assets of people within their country and get that money. Obviously, it's tricky because in a lot of these less developed countries, there's a lot of political shenanigans that can go on where you would just seize the assets of your political rival, and so there are all kinds of, it's very fraught, but that's also a thing that we're seeing where the countries see that as a way that they can benefit while at the same time enforcing laws that will long-term benefit their country.
Yeah, thanks for that. And I wanted to move on to sort of the next topic, which was the impact of COVID-19. Obviously, the pandemic has affected all of us in many different ways, not the least of which is that we're doing this webinar from our home with, our kids in the next room doing Zoom calls. So, but, obviously it's affected companies as well and the way they do business and also the way anti-corruption laws are enforced. Let's start with sort of compliance concerns. How has this global pandemic affected the ability for companies to do put the proper compliance procedures and policies in place related to anti-corruption? Maybe Becky, do you want to start with that?
Sure, thank you. I think that one issue that's come up is working with third parties. For example, conducting screening of business partners and suppliers. And my suggestion here is that companies do need to keep doing this. They need to follow standard anti-corruption controls, maybe with more flexibility as to time and taking into consideration the lack of ability to sort of have on-site, on-the-ground presence. But the vetting and the checking of red flags still needs to take place. And I think it's important to note that, despite the resource challenges and the restrictions that are going on around the world, this is not the time to bend the rules. I do not think there will be sort of any coronavirus defense or any forgiveness by enforcement authorities if the compliance controls that a company had set up were not followed during this time. Even though companies often need to shift their supply chains these days and maybe onboard new suppliers and from a different country, that makes it even more important that due diligence take place, not less important.
Becky, I have a question of you. Do you, when you are doing due diligence, especially on significant third parties, and you feel the need to do a more in-depth investigation, how do you meet that challenge during this COVID-19 situation? Usually you'd hire an investigator to go out and do some digging. Do you find that you've been hampered in doing that with COVID? And how do you get around it if you have been?
So there is less of an ability to send somebody out to be on the ground. However, I think the need for that is so small because, as we've seen over the past few months also, there's a lot of information you can get from being at your computer, at your desk. So you can contact the partner or the supplier, ask them questions through a questionnaire or through an interview. There's a lot of information that's available online through just desktop research, and you can subscribe to databases that give you even more information. You can use Google satellite photos instead of sending somebody on the ground to take photos. You can conduct phone interviews with people. I think there's limited situations when either a partner or supplier has red flags that you think you want to address by being on site, or if they're located in a country where there's just not a lot of information available online that you might need to send somebody out. But I think the vast majority of third-party diligence can be done remotely.
And in terms of investigation or even working with the DOJ in investigations, I know there's been a lot of sort of remote depositions, remote presentations. Have you guys had those experiences thus far, and how have they gone?
I think that you can do meetings like this via Zoom with enforcement authorities and regulators just as well as with colleagues. And I think that's going to be the way forward for, for a while now.
And
Sort of a new way of doing business.
I think some of the challenges with COVID in terms of whether or not it's an internal investigation run by in-house counsel or outside counsel is we're all working remotely, and record retention can be an issue. The collection of records, the additional locations where records now can reside can be an issue for conducting, especially an expedited investigation. So that I think is a challenge that we find during COVID. It's always been a challenge in internal investigations, but it's become more significant as people are located at home as opposed to in the office.
I think for internal investigations, often it's possible to get emails and documents from the cloud or from a company server, but there are some instances when to conduct an investigation, you really need the hard drive on someone's laptop or you need their phone. And in those situations, there's no way around it. You have to get them physically. But now that we're sort of 6 months into this, I think it's easier to arrange a safer handoff, and people feel more comfortable doing that than they did before. However, it is obviously not the same as when people were in an office space and you could just go there and take it.
Yeah, if you've got a situation where you feel that documents could be deleted, or it's important that you act in a way that, there's an element of surprise, and usually that's a serious situation. Obviously, that is hampered during COVID. I think that actually is, I don't really know how significantly more hampered you are. In my experience, if employees get a whiff of an investigation, and they're of a mind to do it, they're going to be deleting documents anyway. So you probably would have the problem whether or not they're in the office or at home.
Right. I mean, on the other hand, one thing that I think is a plus, for example, I did an existing third-party audit for one of my investigations, and it was great because rather than me rifling through, and we got all the information, that was the part that was good, and they happened to be cooperative. Obviously, if they're not cooperative, it's a totally different situation. But I didn't have to go through any hard documents, etc. They basically found everything and scanned it for me, and then it was all on my computer. So that was great. And the other thing I think is really good too is that sometimes when you go in person and you have to go boom, 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 like 5 people back to back or 10 people back to back interviewing, you don't have a chance sometimes to digest what you found. So, you can do it when you're doing everything remotely. You don't have to constantly be going back to that country. You can just call them again. And so you kind of have this luxury of getting things in steps, and then you get the information, you can digest it, you can really just decide right then what you want, but you can kind of take your time a little bit more, which for some investigations is helpful, because obviously if you're there doing back to back, it's only after you leave that you think, oh God, if only I had looked in that one closet or whatever. Whereas, here you can spend a little more time sequencing the investigation just right. So I think that's a plus as well.
Yeah.
Thanks. So moving on to the next topic, recent guidance documents. I know earlier this year there was an update to the FCPA resource guide. I think it's funny. I think when the first FCPA resource guide was issued 8 years ago, it was this big deal. The AAG at the annual FCPA conference announced this resource guide and how it was going to change how companies can be compliant. And then this update that was released earlier this year came out, I think, on like July 4th weekend, and no fanfare at all. I mean, it's quite different. Is there, Joan, I know, you've looked at the resource guide and sort of the updates. What are the big sort of updates or changes from the original one to this one?
I think that the guide is substantially the same, but there are little differences that are kind of notable, I would say. The first one, we've talked about Hoskins, and the new resource guide has obviously incorporated new policies like the updates to the evaluation of compliance programs. The new corporate enforcement policy is now part of the guide and used as a resource. They made a few corrections, like the criminal accounting provision is a 6-year statute of limitations rather than a 5-year. And they've talked about recent cases like the Hoskins and Firtash case, where they're acknowledging this decision out of the Second Circuit, where it's clear that they don't agree with it and they want to limit it to the Second Circuit. They also give kind of a brief nod to some of the cases that have come out of the Supreme Court regarding the SEC's remedy of disgorgement, where disgorgement is now got a 5-year statute of limitations because the Supreme Court construes it as a penalty. Another recent case basically said that disgorgement was permissible where it doesn't exceed the net profits gained by the scheme and it's awarded to the victims. Some other nods to cases that I think give good instruction to counsel, in-house and outside counsel, about how to determine what an instrumentality is, like the 11th Circuit opinion in Esquenazi, which actually gave a number of factors that basically, if it meets a particular test, it would be a state-owned or controlled entity, including whether or not a foreign government has a majority interest, whether or not the entity itself is subsidized, whether or not the entity is performing what is construed to be a governmental function, and there are factors that go into that analysis. And the guidance incorporated that, which provides further specific, direction to people trying to divine how the federal government is going to be looking at these issues. Some of the cases that they cite show their viewpoint on particular issues. One, basically some harsh language about anyone trying to take advantage of the local law defense as an affirmative defense under the FCPA. They cite to a case that basically indicates that was being raised by the defense that there was a local law defense, and the district court rejected that defense. And in the process, DOJ talks about the defense being very infrequently used, and essentially kind of, along with facilitating payments, discourages companies from ever trying to use that particular defense. And when I say facilitating payments, I mean, the argument that facilitating payments are legal under the laws of a particular country. So there are a couple of omissions that I think are interesting. The first one is that in their the resources that they want people to rely on, that they don't include ISO certification materials. So, you wonder what that really means. They don't really talk about the Yates memo and expand on what was a focus in the prior administration about holding individuals accountable through individual prosecution. They do make some points about where a compliance program and an internal control evaluation intersect, and they talk about the fact that it's important, as part of an effective compliance program, adding additional language about making sure to investigate misconduct, analyze that misconduct, remediate it, and they want to see evidence of some sort of discipline. And in my experience, I think that the DOJ is elevating that focus, that where they want to see monitoring, they want to see evidence of thorough investigations regularly undertaken, and evidence of the use of disciplinary proceedings by companies to discipline those employees that are, guilty of misconduct. And I think that in talking about compliance programs with government prosecutors, you're going to see those questions asked much more frequently.
So in the interest of time, I'm going to go on to our next section. I note that in our handouts, and if you can't download them, we will send them to you. In our handouts, we do discuss the evaluation of DOJ's new document, the evaluation of corporate compliance programs, as well as the new opinion procedure release 21, which we'll send out to everybody. It's funny, when we planned this, I knew we could have gone for an hour and a half, but we try to keep it for an hour for everybody. So just to a final point, because I know there are a couple questions that I do want to get to from our audience. So I know, Mara, you mentioned kleptocracy before, and there is a new Countering Russian and Other Overseas Kleptocracy Act that is pending in, and I use the word pending pretty strongly, I think, with Congress right now. What exactly is that act, and where do you see that going?
Yeah, I basically will run through all three of these quite quickly so that we can work in a couple of questions. But the Crook Act, which I love the name, the whole point of it is to give the State Department a percent of the FCPA collections, I would call them. So basically fines and fees that are collected by DOJ, at least in the current version. It's altered a little over time, but the State Department would be given 5% of that money in order to bolster the anti-corruption programs of other countries, including, places like Armenia, where there's hope that they can really actually turn it around, Ethiopia, when, the civil war ended, things like that. So I'm sure that there are people in the government who don't think State Department should get more money. I love the State Department, so I'm not one of them. But the other issue is that the State Department already has a lot of money. Every time I did anything overseas corruption-wise in terms of training, the State Department was always there. So I know they already have money, and I bet I'm not the only one who knows that. So I'm not only because of that, but I don't really I haven't seen much movement on that, and I'm not expecting there will be. This, I don't know if you guys have noticed, but this Congress is not super productive. So I'm not really seeing that one go through. The Foreign Extortion Prevention Act, which has a lot lamer of a short name, FIPA, so no one's ever going to say that. Basically, the whole point of that is to expand the FCPA to foreign officials so that bribe recipients, the demand side of corruption, will be covered. I also think that is a great idea. It is somewhat controversial, though, because a lot of those officials can already now and have been if you're an LLC and you incorporate or file in Delaware, I know nothing about you, but if you're in Florida, I know everything about you. So the point of the Corporate Transparency Act is basically the way the mechanism works is that the states, none of the states wanted to take this on. They didn't want to report directly to, they didn't want to open up their coffers, because then, of course, they would have to pass it through 50 different state legislatures. So instead, it just imposes an obligation on the state to report to FinCEN, and FinCEN would then become the central repository of all this information about who owns certain entities. And it would not, unlike some places like in Britain, they have a public corporate beneficial ownership registry. This would be only accessible to law enforcement and banks who are doing know your customer kind of checks. So, but this one, it did have bipartisan support. So I'm guessing that within the next few years, hopefully it will pass.
Right. Agreed. Yeah, I saw that. I agree that I think that one for sure will be passed relatively soon. We'll see. But just quickly, I wanted to go over a question and then we can close for the day. There's a question that is some countries restrict the handover of evidence to U.S. authorities through blocking statutes. Have you encountered such cases, and what would be the recommendation for multinationals facing multiple investigations in different jurisdictions?
I mean,
That's a tough one.
Yeah, it depends. The answer, of course, is it depends on the jurisdiction. But one really interesting case that came out of the Southern District maybe 5 years ago, and this had to do with it was a blocking statute. It was similar. It was equivalent to a blocking statute. And the holding in that case was the only way that the U.S. government, the only way that courts, and in this case it was just a district court, and I don't think it ever went up, would honor blocking statutes is if the country itself took it seriously. Actually, it was a bank. I think that was a bank secrecy case. So basically, there were there were 4 or 5 countries at issue, and the judge went through every single one. And Switzerland, they found that Switzerland was the only one that took their bank secrecy seriously, and so he blocked the government's access to the Swiss documents because he found that there was a comedy consideration that we respect a sovereign who actually enforces their own laws, and they themselves think it's important. But there were other jurisdictions, I think one of them was the UAE, that had something on the books, but they never actually enforced it. And so he said, we're not honoring that because that's basically just a paper policy and it's never enforced. So one thing to look at, I think, would be whether or not it's actually enforced in that country. The government takes a very dim view of all of those defenses, no matter what. I mean, even if you're completely legitimately there, because to them, they don't care about your jeopardy in other countries. So they just say, I want the information. And so I've had clients in the past that basically, I'm certainly not advising this, but it is a risk-based analysis. And I have had clients in the past that say, well, the risk of me being prosecuted, I mean, in this case, it was a civil statute, or fined for doing something, to me, is less important than my fear of the US government and what they will do to me. And so unfortunately, the government sometimes puts you in those situations, and they always say lip service. We would never tell you to violate any law. Absolutely not. But then, you're between a rock and a hard place. And every now and then, hopefully not very often, you have to make a decision like that, or at least find a legal opinion that will shelter you in the case that it ever came out.
Yeah, I think that there are a variety of different techniques that a company can use, including collecting the documentation in the country, reviewing it in the country, making a determination if there are other ways. Sometimes you've got duplicate documents in a country where it could be fairly turned over. Communicating on a high level what the results of the investigation were without turning over the documents. I know that in some instances, the United States would make an MLAT request to the foreign government to get particular documents. So I think that's been utilized in the past, although I've never done that. So there are ways around it, but it is a very difficult issue. And I found that, companies are legitimately concerned about data privacy issues and blocking statutes, and they don't really want to be on the back end of that if they can avoid it. But that is one of the features of the resource guide that I've always felt was a little problematic, in that there is not much guidance. As Mara said, the U.S. government wants the information and they expect the company to get them the information during an investigation.
By the way, Samir, someone also popped in that we should say the CLE code.
Yeah. So, I think if we want, we can end there. And the CLE code for today's program is CLE 930. That's CLE 930. I do want to thank you, Mara. Thank you, Becky and Joan, for participating in today's webinar. I thought the information provided was really great, and I really appreciate your efforts today. For those if we didn't answer your question, for those of you who asked questions, we'll definitely send you an email with some response. Secondly, if you have any additional questions, please feel free to reach out to us, and we'll try to get to you that way. Afterwards, we will send some of the handout materials over email. Again, I see again. So again, the CLE code is CLE 930. Thanks again, everybody. Have a great rest of your day and great rest of your week. Thanks.
Bye. Thank you.
See ya.